Hi, I'm Denice Gierach of the Gierach Law Firm. This is another video in our series on the sale of businesses. And this one I want to look at different contract considerations that a buyer and a seller may have, because their interest in going into a sale or a purchase of a business can be quite different. So before you sell your business, one thing that's important to understand is that you, as a seller and the potential buyer, do have different considerations that you may have in the negotiations of a contract for sale. Your knowing this will allow you to negotiate better with that buyer, rather than wondering why that buyer is raising issues that you may think are just an impediment to doing that sales process. Here are a couple of examples of the differences. One is, a seller generally wants to just sell the stock in their business. A buyer would rather buy the assets of the business and then cherry pick what liabilities that they would assume. The reason for this is that there is always a possibility for that contingent liability popping up. Like someone who sues the business for a slip and fall in the plant, or a product liability issue, an issue with a team member, or an environmental issue, a tax issue. There are any number of things that can turn up after the sale is completed, despite the seller's attempts to complete disclosure at everything. Although the contract may hold the seller liable for things like that, that occurred before the date of the closing on the sale, the buyer still has to defend the claim, and then find the seller, hoping that the seller still has the money that was paid. From the buyer's standpoint, it's a cleaner method just to buy the assets they want and leave the seller with the corporation or the LLC. That way, the buyer is not responsible unless the buyer indicates that they will be. Another reason that the buyer wants to purchase assets is for the tax treatment of those assets. The buyer can allocate the assets in a way that the buyer and seller agree that will allow the buyer to depreciate the assets faster over a shorter period of time. That saves the buyer taxes over the years after closing. On the other hand, the seller would prefer to sell the shares of stock in the company or the membership certificates in the LLC. The seller would be subject to capital gains treatment on the difference between the sale price and the seller's cost in the shares of stock or the membership interest. If the seller sells assets, however, there may be ordinary income to the company for the recapture of depreciation already taken. Then, when the seller liquidates the company, there may be a second tax to the seller, except for some pass-through entities where they have different tax considerations. It's important for the seller to have a great CPA to navigate this part of the process. Just what is going to be sold? This is usually all of the operating assets of the business, but what is really included in that? The business many times has real estate that it operates in. This may be a lease for a property that another company owns, unrelated to the seller. Many times the seller wants to sell everything, including that real estate. This buyer, on the other hand, wants to buy just the operating assets of the business and not the real estate, thinking that they might move the division into an existing building that they already have. If the buyer does that, what does the seller do with that building, that real estate? Can it be sold separately at about the same time of the sale? Will it be empty for a while with no income to pay the real estate taxes and maintenance? If it's a lease, will the seller be able to re-let that property easily, or be stuck with that lease on the building for a long time when it's no longer using it? What about accounts receivables? Who will collect the accounts receivables? Will the buyer want to pay for the receivables up front and accept the accounts receivable aging report? If not, and the buyer collects these for the seller, will the buyer allocate payments to current purchases versus old purchases for the seller? Will there be a confusion in the mind of the customers if the seller is authorized to collect these? Most of the time, the buyer will collect the receivables and either pay the seller for them as part of the closing or pay them monthly based upon what they receive. Is the buyer buying your intellectual property and your new products that you're developing now? Sometimes these are integral to the sale, and these different products may not show up on your financial statements. Other times, you're not ready to put these products into the marketplace yet, and the seller may want to retain these products and the intellectual property supporting them to develop them separately as a new business. If these are part of the sale, then you need to have them separately valued in order to increase the price to that seller for these products. And maybe give the seller a royalty interest in the sales over a period of time. So who will be taking over the accounts payable and the other liabilities? The seller generally does not want to save or have the responsibility of making these payments to vendors as they come due. Usually the buyer will take over the payment of normal accounts payable, which is figured into the price of the business at the time of sale. The buyer will normally not assume any lines of credit or long-term financing obligations that the seller has. That will be their obligation. What about the team? What are the differences here between buyer and seller? The seller who has worked with the team members, many for a number of years, would like to ensure that the buyer takes all of the team and will give them employment agreements over a couple of years so that they are not without a job as a result of the sale. The buyer, on the other hand, may look for efficiencies in the business, thinking that they already have a great CFO who can manage both of their businesses, or a COO that can do the same. Even if this is the case, many times a buyer will keep the key players in place until 6 months to a year after the sale to make sure that they keep the business intact and keep from losing any business. Sometimes the buyer will need to give a signing bonus or other incentive for these people to stay. A great team member may want to leave for other long-term employment, but may stay for a period of time with that extra incentive. What about the seller? Is the seller staying to manage the businesses for a while? Or will the seller just be on call for 6 months? Many times it is the latter. The buyer wants the seller to be there to go out to introduce them to key customer relationships, to help ensure that they will keep those accounts. When they feel like they have the relationships cemented with that new team, they may not want the seller around to potentially countermand the new team. On the other hand, Many times, the buyer wants the seller to stay 3 to 5 years to grow the business. Maybe the buyer is bringing extra capital to allow the business to grow, and will give the seller a strong incentive if the business grows in that amount of time. If the seller finds that the buyer will allow the seller to control over that period of time, this might be a good solution. Remember that the buyer will want to potentially allocate a portion of the business sale to an employment contract for the seller in order to get ordinary deductions for those payments. If the seller is actually going to work for the buyer, this is probably most likely the case. Another area of difference in the area between buyer and seller is restrictive covenants. These are generally non-competition clauses, non-solicitation clauses, confidentiality provisions, and non-disparagement provisions. The buyer would like to have provisions that are as broad as possible. The buyer wants to ensure that the seller does not go into business in competition with the buyer for a period of years, as the buyer has just paid the seller money for that business and does not want to have that seller try to use that money to go into a competing business. The seller does not want to leave after the closing and have nothing to do. This is what they know, and this is all that they think that they are going to be able to do. So they would like to continue to work, even if it is a position in the business that is internal and never touches former customers. The seller wants to have as little in the way of restrictive covenants as possible so that the seller can do something in the future to work. The reality is that the language must be negotiated in a way that will be acceptable with the buyer and the seller. This may be to allow or lower the time that these non-competes actually work, or the geographic area, or to allow the company or the seller to be able to do other things as long as they don't interfere. If you've ever reviewed a sales contract, you will usually see pages of warranties ranging from the company being in good standing to the financial statements being true and correct. There may be environmental warranties or on the intellectual properties, potential claims against the company, and so on and so forth. In this case, the buyer and the seller also have different points of view. The buyer would like to have many warranties as possible and as broad as possible. The buyer wants to ensure that if anything turns up after the closing that the buyer didn't know at the time of the sale, that it will not be the buyer's responsibility. The seller wants to fully disclose before the closing and then walk away from the business with no further responsibility for things that may come up later. The reality is that each warranty needs to be thoroughly reviewed and refined between the buyer and the seller, so that each buyer and seller are going to absorb the risk that they'd be willing to accept. Sometimes the buyer wants to finance through the seller. If the seller agrees to this, they are taking the position of acting like a bank. The seller needs to act like that bank in order to make sure that they can approve the buyer's credit, get that personal guarantee, to make sure that things are okay. And if they default, to be able to negate those non-compete provisions to allow them to go back into business in the event of a buyer default. The banker has all of these things at their hands, and you, as the banker for that transaction, should do the same thing. So, what is the bottom line there? The seller and the buyer have very different interests as they negotiate a contract for the sale of that business. To navigate this process, it's important that each side has their teams in place. A great attorney with lots of experience in the merger and acquisition area, a great CPA to know the tax consequences, and a great broker to help establish the ground rules all from the start. It starts with your team that you've built, and you can get the best sale out of your negotiation if you do it right. I look forward to seeing you next time.